At number one.
No, they have filed their affidavit.
This is the age, no?
Age, regarding age.
Clarifying in absence
58 years, they have taken
In the-
58 years.
certified. In the
Public
certified
24
standing
years.
order stipulated the age of retirement, what would be the age of retirement in the private industry in Assam? Whether the Assam so and so has been brought into court and whether the central will prevail in absence of the standard. Now let's see what is the affidavit filed.
My lord, affidavit starts, my lord, from 173, my lord.
Paragraph 3.
This is paragraph 3, where there is no agreed age.
My lord.
Retirement or superannuation shall be on completion of 58. What is
But that is not there in
understood?
in the rules also. It's
Understood.
not there.
58, then 24 years of
24
age.
years.
What is
But-
this?
Maximum is 58 years, my lord.
And what is this 24 there?
On completion of, my lord, whichever is earlier or whichever is later, there must be some specification, my lord.
This is not clear.
My lord, lordship, first of all, for the timing, my lord, again, I'll just take instruction on that, my lord, whether whichever is because.
No,
24
why
years-
is this affidavit in such a manner where there is no age? Agreed age, retirement of superannuation shall be on completion of 58. What is this 24 years of age? by
24 years by the workman, my
No,
lord. The
that is
continuous
not in
service
the-
of 24 years,
So
in the
we have
rule.
to,
my lord, maximum age.
first,
limit
it is not clear from your standing orders or certified orders to that effect. This court further asks as to whether that particular central rules shall apply.
My lord,
Number one, this court further asks the question as regards industrial employment standing orders, central rules 1947, 46 would prevail in absence of the standing orders.
my lord,
Whether the industrial development standing orders amendment draft rules has been brought into force. Where are those answers?
my lord, they have only stated that for 58 years is the, my lord, age limit, my lord.
Where? What is the basis?
Lordship, 1 week time may be given, my
Or
lord,
what?
for.
This is a
clearing of
2011
this-
matter.
Lordship,
Then
or my lord, on Monday, my lord,
Monday,
I'll bring on record.
Monday, I think it
my
will
lord,
be-
the,
Monday, I don't know. It may be closed.
No, in fact, Lord, you can go through, if you go through the provisions of the standing order, Lord, there is a specific provision, if the Lordship goes to the age of retirement.
Where?
Yeah. Model standing order, schedule 1B. Well, actually, industrial standing order is applicable to the all industrial establishment. Now,
central,
Rule 15
Model standing order. Yes.
empowers the central government to frame rules. Accordingly, these rules were framed in the year 1946, 47, 46.
46.
And two model standing words. Sorry.
So are you saying that these rules shall override? If there is no standing orders,
These
these
will-
rules will have to apply.
Yes, my lord, that seems to be my lord. So
No,
my lord, maybe-
their agreement, their affidavit is also in this,
yes.
that external.
Yeah, I
in
believe it.
this-
I don't know whether that person concerned knows English or not. Who is this person who has signed?
The age of retirement, here if your lordship will find.
Deputy
exactly,
Secretary to the Government of Assam
Oh,
Labour
deputy.
Welfare Department.
Yes.
Is he not aware what is how English is written?
They have quoted it from that rule,
I understood, but what is this 24 years?
24 years ago.
This, I have directed the Labour Department to file the affidavit only on the ground that these are a lot of ramifications later on in which will happen to everybody.
In all the cases.
Where there is no stand in the standing orders, certified standing orders, there is no age given. How do you take care of it?
Right.
Then, first of all, you don't have the draft rules of 2005. What is the effect? You have not mentioned. Number two, as regards whether you have adopted or whether that model rules is to be adopted, is the stand of the Labour Department. And why on earth the Labour Department cannot answer to this and puts it in this manner?
Clear answer is not there, my lord. My lord,
We ask because you see now the Deputy Secretary of the Government of Assam Labour Department does not know head or tail about English. So we'll ask the Commissioner
my lord,
of the Labour Department to file an affidavit as he doesn't know how to write English.
my lord.
Therefore, or to be personally present
My lord,
with the records.
my lord, 1 week time may be granted, my lord.
No, this is not done. This is a
I- I-
2011 matter.
My lord.
Then
Last occasion, lordship pleaded, my lord. Lordship
there was, I passed the order on 22/6.
My lord,
Then the matter came up before Justice Sumitra Saikia.
my-
Purely in the interest of the matter is adjourned for a week, enabling you, thus so and so appearing on behalf to file an affidavit. Yeah,
my-
So they have quoted it from rule 3. Only thing is that they have inserted 24 years. That has created a problem.
no,
Probably,
no,
probably they
Mr.
want
no,
to
Mr.
say,
No,
they-
Mr. Dasgupta, this court had asked them 3 specific questions.
that they have.
There's no answer to that. Therefore,
Insertion of 24
this court
years
by
has
an
created
order
problem.
dated 22/6/2023, taking into account the wide-scale ramifications insofar as industries in the state of Assam, wherein the standing orders do not contain the age of retirement of the employees, had directed the Labour Department of the Government of Assam to clarify 3 aspects of the matter, which are again reproduced herein under a paragraph 4, 1, 2, and 3. This court further directed by the said order for filing of an affidavit by 18th of July 2023. Full-stop. It reveals from the records that an affidavit was filed on 4th of August 2023. To the surprise of this court, to the utter surprise of this court, the contents, the relevant contents of the said affidavit is quoted herein under. That is paragraph number 3. The above, therefore, does not in any manner show that the affidavit was filed in terms as well as in compliance with the order dated 22/6/2023 passed by this court. With great displeasure, this court finds it, this court takes note of great displeasure. This court observes that the Deputy Secretary to the Government of Assam Labour Welfare Department have filed the said affidavit in a perfunctory manner without addressing to the points, without addressing to the queries so made in the order dated 22/6/2023. Taking into account the above, this court fixes this matter again on 24th of August 2023. It is made clear that the affidavit be filed by the highest authority in the Labour Department. Answering to the queries so made in the order dated 22/6/2023. The said affidavit be filed by 21st of August 2023. And failure to do so, the Commissioner and Secretary to the Government of Assam Labour Department shall be personally present before this court on 24th to explain the queries.
Lordship, oblige.
And number two. Yes, what is your case?
So this case pertains to professional lordship. I was working
Hmm?
as sub-inspector lordship. I was working as a sub-inspector in the Assam Police lordship.
Then,
Lordship thereafter lordship, my services were confirmed lordship. Subsequently lordship, a promotional exercise was undertaken lordship. And lordship, juniors to me were promoted. Lordship. The promotional order, your lordship will find that lordship. And it's page 23 lordship. The type. The type of page.
so what remains?
Lordship, in the promotional order, lordship, page 23 it states, the promotion is considered in order of seniority. technical-
Understood, but what remains in this matter? Can he be now promoted?
Lordship, probably.
He
by
must
now,
have
He
retired.
must have retired.
No, he has retired.
Lordship, he has.
Unless the government of Assam has increased the age. This was, his petition was filed in 2011. He was 53. So today is another 12 years. He's 65. Is the age of the government 65? Then what remains?
Lordship, this promotion that was denied to him was illegally done. Lordship, the promotion is review division, the promotion is the final.
So what will be done now? Tell me. Can this court direct for having it notionally on that day and then to promote him and then give him all the benefits? Can this court direct? Tell me now. Understood, if he was in service, something could have been done, but he's not.
Independency is there, Lordship. Now
You should have mentioned the matter. The respondents to produce the records of the DPC as well as other so-and-so pertaining to the promotion to the cadre of so-and-so. The petition raises an error that juniors were promoted to the cadre of so-and-so, and the petitioner shall take a stand that there was an adverse service conduct because of which the petitioner was deprived. That records be produced may indicate whether adverse remarks were communicated to the petitioner. But whatever may be, it is a case of denial of your promotion. Promotion has been given to somebody else. Now, can this court now grant that you promote him when he is no longer in service? It is very difficult unless you show something that somebody has done so. Isn't it? You are supposed to produce the
Yes, Dr. but the record is here, but I have seen that he has already retired in 28/2/2018. And without holding the DPC, promotion cannot be considered.
So your prayer is to hold the DPC. Now, can a DPC be held now
No, no, that cannot be.
in respect of a person who is no longer in service? Nothing. I can't help you. You may have a good case, but the case ought to have been at the proper time. Hint. The rule was issued in 2013. Writ petition was filed in 2011. Surprisingly, the first order passed is on 2013. Why? You kept it defective. Obviously, I know you were not there at that point of time, but then also. The instant writ petition has been filed by the petitioner for setting aside and quashing the notification dated 28/10/2010, as well as a notification dated 16/2/2011, and for a direction to the respondents to convene a review DPC and to consider the case of the petitioner for promotion to the cadre of Inspector of Police, the UB, along with the incumbents promoted by the impugned notifications dated 28/10/2010 and 16/2/2011. At the time of filing the writ petition in the year 2011, the age of the petitioner was 53 years, as could be seen from the affidavit. As on today, 12 years have passed by. Mr. H. Sharma, the learned counsel appearing on behalf of the respondent, submits that the petitioner had already retired on
28/2/2018.
28/2/2018. So taking into account the above, this court finds that the relief which has been sought for the present for holding a DPC, thereby to consider the case of the petitioner, cannot be granted in view of the retirement of the petitioner. Accordingly, this court finds no merit in the instant writ petition in view of the subsequent in view of the retirement of the petitioner, and accordingly the writ petition stands dismissed. I think you must have got promoted in the meantime. 100% something must have happened, and you have no contact. Your senior must have said, your name?
Age of approval.
A. Chakraborty, kindly do this matter. I won't go.
At number 3.
What is this matter, Mr. Pegu?
Dismissal from service, my lord.
Huh?
Dismissal from service.
For why?
The offense is, my lord,
The labor
while
court.
on duty, my lord, under intoxication, my lord, he fired 4 rounds of bullets,
Oh, that one.
my lord.
Then what happened? Where's the other side?
Okay, good.
But that was at that point of time that he was the criminal proceedings were in his favor.
My lord. My lord.
But the fact remains that you have found that he has used these 4 bullets out there.
My lord.
Has he vacated the quarter?
My lord. So, my lord, here, my lord, the DP was conducted with due compliance of the statutory provisions, my lord. And he has not challenged there also the petitioner side.
Huh?
Petitioner has not challenged, my lord, because in order to prove, my lord, they have to prove malafide and arbitrariness, my lord. That was not. That is not there, my lord.
You are there? Mr. Counsel, yesterday that matter is I have disposed it of. Now tell me whether that acquisition was done under the old act or under the 64 Act?
Yes.
Not the 1894.
By 1894.
How is it 1894? Then how can it be in 2018? An LA case of 2018 was there.
One is 2013, the other one is.
Are you saying that 2018 is under the, then why did you move an application under section 12 of the 64 Act?
That my lord, I need to reconfirm.
What?
I need to reconfirm whether that is for 18 or that.
It couldn't have been. Then why are you moving under section 12? And if it is under 1894 Act, you are finished. Section 18 comes into the play. Section 18 says that within 6 weeks or 6 months.
Right.
Then why it is not clear in your petition? Under what provision it has been done? The Legal Service Authority needs money to be paid from the pocket of the client, of the lawyer. Don't you think so? While while dictating the order, I found out the legal services needs to be paid something. Or nowadays the president of your bar association says that the amount be deposited in the advocates welfare fund. Do something, I think. Huh? 5 lakh each.
That may not be.
Huh? Cost?
No, man, that.
Then why haven't you mentioned out there under what provision it has been done? If it is done under the 2018, wouldn't 64 come in? But this was done for the dike. And 100% the government does not exercises the 2013 Act.
that was
So they will do under the 64. So you did under 12. And the other one was 2013. You also did it under 12. I passed the order. Only thing I wanted to clarify to that effect, was it done under the 64 Act? So that is, I've got it. It has to be done under the 64 Act because you filed under 12.
Yes, ma'am. And one case is with regard to 2013. So that would be in the 2013. Because the one against one court of line, it was the LA case was of 2013. So probably this 2013 Act would not have come.
2013 won't be there, but it will be done under 64. Because you filed under 12. So if you file under 12, that is that. Yes, tell me, what is your case here? You have fired 4 rounds of bullet. It is a fact finding which has been already arrived at by the authorities. What is the perversity out there?
My lord, if I had that fired 3 bullets, my lord, they got only 1 cell. After I fired the bullet, they would get the remaining part of the cell. They only recovered 1. Rest 3, there is nothing. So
So
if
one also they have recovered.
Immediately.
yes, my lord, 1 is they recovered, but the thing is that whether I have fired it or not. That was
But-
my lord.
Am I sitting out here as an appellate authority?
No, ma'am.
So how can I go into and look into? This is absolutely within the domain out there. They have done it.
But my lord,
The
again.
fact finding, unless you show that there is a perversity out there on the face of it, and as such, there is no firing by you. Their allegation is specific that you have been in intoxicated condition, you have fired a bullet.
Yes, my lord.
That itself is 1 bullet or 4 bullets. That itself is a serious misconduct.
Yes, madam, that is with regard to charge number 3, but charge number 1 that I was under the intoxication of the alcohol, my lord. That, my lord, only there is that the witnesses stated that I was under the influence. That has been denied by me. Now, those witness, in respect of my, the FIR was lost, that was before the trial court. Those witnesses before the trial court have deposed that they thought that I was under the influence of alcohol during their cross-examination. Whereas during the departmental, they said that yes, I was the influence, but when they were put on cross-examination before the trial court, they
Mr.
said,
Counsel, tell me, how can this court, the departmental proceedings or departmental officer exercise the power under section 45 of the Evidence Act and get the records or the evidence from the other place in another proceeding and decide. Tell me, is it possible?
No.
No, it is only for the court.
Right.
So did you produce these evidence before the inquiry officer?
The inquiry was, this was already completed, the trial court has come on later.
Then,
But my lord, regarding the.
so as of, you see, this is a finding of fact that I did. You see that there is a difference. In a criminal proceedings, the proof has to be beyond reasonable doubt, but here has to be on the basis of preponderance of evidence. So under such circumstances, a person may be guilty in a departmental proceedings, may not be a guilty out there in criminal proceedings. And there are many plethora of cases in that regard.
Only thing is that their statement were considered to be an evidence. In my written statement, I have denied it. Regarding, in order to refute my denial, my lord, there is nothing.
Hmm?
In their statement, they have said that I was under intoxication of the alcohol. In my written statement, I have denied it. After my denial, my lord, there is nothing to show that yes, there was something or not. There was no medical document, nothing. Only that part.
Medical document, what is there to have medical documents out there? To add, okay, now can this medical document be done immediately? Or
I was saying.
now, are you telling me that at that point of time when the particular the rules which are applicable, if a person is health intoxicated, he has to be medically examined, which is otherwise required in a criminal proceedings. But is it required as per the rules?
As per the departmental proceedings, that is.
No, not the department. As per the rules.
No.
You are under the Army Act,
Yes, CISF. CISF.
CSF Act.
I guess.
There must be some rules.
There is
Does
nothing-
the rule say that a person who when caught has to be on the basis of this, or would it be on the basis of the evidence? So he says, 4% says that you were intoxicated, you say that you are not.
that much on record.
Then how does this court decide? And when there are 3 fact-finding inquiries, we have the authorities, that is the first inquiry, it's fact-finding, appellate fact-finding, that the revisional authority has also looked into it. Then how do I say that this is not correct?
Lord, recently, my lord, 2023 Supreme Court 622, my lord. Here, my lord, only threatened the higher officer, possibly under influence of intoxication. He was also dismissed from service.
And he wants to put a nail on your coffin. Give it to me. But what do you say about the bullet, the firing?
That was never an intentional matter.
No. What do you say about the firing?
Malad, that is an automatic rifle matter. Suppose I had fired it. Malad, I cannot fire 1 or 2. There are the statements that has been recorded. That Malad, that's an automatic rifle Malad. The moment I fire it, at once Malad, all the 19 bullets would go Malad. That is not something like I'll fire once, wait, then second, then third, something like that. Even if there were 90 bullets, Malad, all that.
Did you raise that issue there?
Page 51.
Hmm?
Page 51 of my record set. Last paragraph.
Hmm. What?
That's why your pen yourself agrees that being a
That's
member.
in reply to the charge number, Iman, I beg to submit that in the previous paragraph, I have narrated the factual side and the same can be maybe treated as a part of the reply of charge. two. I never fired any as alleged. So far, the statement of Mayor, I have already narrated as how my arms were snatched away. It is false that I deliberately fired. The bullet snatched the left side of so and so as alleged. I never committed any. Now let us see your previous paragraph.
Page 50, line number 9 from bottom. All three came out from the cook set.
Now let us see the findings of the inquiry officer. Where is the inquiry officer?
That is not been annexed.
Oh, that day also I told you.
Yes.
Translated. Let us see. During inquiry, these facts were accepted by Bodal. Was deployed on UP at Chai when Bearing accused was under influence of liquor, accused without identification.
Second last page, madam, second.
What is your name?
T Patram.
Trilochan Patra.
Left here. What is SMG?
That my lord, name of the gun.
It's like the machine gun,
A machine gun? Semi?
machine gun. I don't know, yes, light machine gun. itu.
Okay, now,
Submissive gun.
okay, this is this. Thereafter, what has happened? The appeal. This is the appeal order, page 78. Or this is the dismissal order.
Dismissal order, madam. Appellate order is met, page 100.
Huh?
Page 100. 18 July 2009.
There were other people also in the mess.
3 more there along with the,
No, you can't be. The mess had only 3 persons. It's a mess.
there is
It will
nothing,
be many more.
there is nothing.
Why did you go to the mess?
My lord, what has happened is that I was at the post. Then one person came in, he thought that you need to call him. I need to have a talk with him. He was in the mess, the victim. I went there to inform him that someone has come up and he wants to pay you the money. The allegation is that all the 3 witnesses, they were stealing the materials from ONGC complex and was selling that to the other person. And in return, that person has came up to offer him the money that has already been taken. For that thing, I went there to inform him that the person has came here to meet you and he wants to personally meet you.
What is the mess?
The cooking hall, madam, where they go and
Ah.
eat, madam.
So why were those 3 persons in the mess?
Madam, that was a lunchtime, madam. That one,
Lunchtime. That is what I am asking.
One
If they
PM.
were in the lunchtime,
Madam.
only 3 of these people were there. There must have been other people also.
Maybe, yes.
Why there was no other witnesses on your behalf?
Only thing is that, madam, there is nothing in the inquiry report to say that I was intimated about the proceeding. That I can adduce evidence, I can cross-examine the evidence. There is nothing on record that although that was offered to me, I neglected to, I did not went ahead for cross-examination or adducing the evidence. There is nothing.
Is it your case in your appeal that no chance of cross-examination was given? If it is not there, well, how is it possible?
His grounds has come up in this decision, my lord,
Huh?
not during the time of inquiry or that prosecution.
They must have got in clever when they got you. What is your name?
It's case, madam.
H.K. Sharma. When he came to know you, he must have done it.
It was filed in 2008.
So, Mr. Sharma, enough. We finish? I couldn't find anything.
Only thing is that, my lord, regarding my lord, that quantum of
There might be. Your stand can be taken. If I was the inquiry officer, I may have taken. Well, not at this stage. It becomes very difficult. Unless you show perversity. If you show perversity, there is a case, but there is no perversity. You see what has happened. You are saying that 4 rounds.
No, no. Against, yes,
They are saying 4 rounds. You say that only one.
fine.
But the police only got 86.
Yes, ma'am.
Where is the 4?
There is nothing to it. Because the
So
moment,
did you use the other 3? Because you were the person who were given this 90 rounds.
yes,
Then where did the other 3 go?
regarding that whether.
Are you not responsible to keep that particular ammunition or the ammunitions which is being given to you?
After the incident had occurred, that arm was snatched by me. That was not in my custody, and that was given to at that moment the police has came up. But on the contrary, the PW1
Are you saying that another 3 were taken away by those other Dubey and all?
possibly because my lord,
But this finding is there's a finding of fact that you have fired 4. And this finding of fact is also being substantiated by the police report that there were only 86 rounds.
regarding
so,
that 3, my lord, there is-
You are now coming up out here and say that look here, there was this, I only fired 1 remaining which were there, the 3 remained. It must have been done by so and so. How can this court look into it? Yes, if it was a criminal court out there, I would have very well said that he has to show,
that is what
but
has-
not in a departmental
that is
proceeding.
what has held the trial court in favor.
And that must have happened out there in the criminal court. They couldn't show.
Because they could not show that at that moment there was 90 rounds that was given to.
So for them, they have to show. But for our departmental proceedings, they will be enough to show that there were 90 rounds to given to you, and out of that, and there's no denial to that fact that there was not 90 rounds being given. Okay.
And
The instant
one thing,
repetition.
that-
Enough, Mr. So
Not in this
this
aspect,
is
my lord.
too much.
Not in this
Enough,
aspect, my lord.
enough.
The repetition that was disposed of, my lord, I was given the consequential benefits for that 5 years period. That
Hmm?
has not been given to me. My lord, prior to initiation of this repetition, my lord, without inquiry, my lord, when dismissal order was passed, I assailed it, my lord, and there, my lord, the dismissal order was set aside and granting that all the consequential benefits to me from the date of dismissal till my reinstatement. That
Till the second one,
the
till the
first-
second dismissal.
No, all
Yeah.
this is all of the paid, my lord.
that consequential benefits, my lord, I have not received for that 5 years period. My lord. That is-
So you are saying from the date on which you are dismissed, earlier dismissed,
My lord.
till the date on which you have been further dismissed.
No, my lord. Till the date of my reinstatement, because the moment I was
Oh,
reinstated. I
After
was
the
suspended.
reinstatement, you got it.
After the moment I was reinstated, my lord, I was again suspended in terms of the present disciplinary proceeding.
So prior to that period, you have not received it. Okay, as you are entitled to that, will pass direction if it is not paid to pay. The instant petition has been filed challenging the dismissal of the petitioner by the order dated 5/5/2009 passed by the Commandant, Central Industrial Security Force Unit ONGC Nazira, as well as the subsequent orders by which the appellate authority as well as the revisional authority had dismissed the application appeal as well as the revision filed by the petitioner. The facts of the instant case that was that on 11 was that on 1/7/2003 at around 13:30 hours, the facts of the instant case is that on 13th, on what is the date? On 1/7/2003, an altercation had happened between the petitioner and some other officials of some other employees of CISF, of the Central Industrial Security Force. At the mess Where is the third order? Third of July order? You have it anywhere.
3rd of July, no, man. Yes, that was set aside.
Thereupon, an order was issued on 3rd of July 2003, whereby the petitioner was dismissed from service by dispensing with the requirement of holding any inquiry. The said order was upheld by the appellate court, by the appellate authority, by an order dated 30/12/2003. It reveals from the records that the said order of dismissal on 3rd of July 2003, as well as the order by which the said order of dismissal was confirmed, were put to challenge before this court in a writ petition being WPC number 2308/2004. This court, by an order dated, judgment dated 24/7/2008, set aside the order of dismissal dated 3/7/2003 and further directed the respondents to confer all consequential benefits to the petitioner forthwith. This court further granted the liberty to the respondents to proceed afresh against the petitioner, but strictly in accordance with law. The petitioner thereupon was reinstated on the basis of the order passed by this court on 24/7/2008 in WBC number 2308/2004, but was suspended, kept under suspension. This aspect would be seen from the order dated 26/9/2008. It further reveals from the records that on 11/10/2008, the respondent number 5 issued an memorandum to the petitioner stating inter alia that an inquiry would be held against the petitioner under Rule 36 of the CISF Rules 2001 to the said memorandum. The articles of charges were enclosed as Annexure Roman 1 and a statement of imputation of misconduct or misbehavior in support of each article of charge were enclosed as Annexure Roman 2. Further to that, the list of documents by which the list of documents as well as the list of witnesses by whom the articles of charges were proposed to be substantiated was enclosed as Annexure Roman 3 and Roman 4. From a perusal of the enclosures to the memorandum dated 11/10/2018, the 3 charges leveled against the petitioner are reproduced hereunder, page 45 of Pavadi. That on so and so, that on so and so, and that on 1, 2, 3. ठीक है sir? Page 45. It further reveals from the records that the petitioner herein had submitted a reply on 21/10/2008, 8 or 18?
8 months.
8. In paragraph number 9 of the said reply, it was the stand of the petitioner that he was on duty on 1/7/2003 at 13 hours to 17 hours, and he signed the duty register under Sanjay Dubey, and the allegations of influence of liquor was a fabricated one. He further stated that had he been under the influence of intoxicating liquor, he would not have been allowed to join his position. It was further mentioned that once Boljender Singh, Constable, number 92229, was released by him, and the petitioner was in the main gate Morcha of Chai Rig of RDS sector. He further stated that after he took charge of the main gate, which was at a distance of 30 feet from, which was at a distance of 30 feet from the mess oblique the cooking heart, he heard a big voicer oblique hue and cry in the cooking hut and the sound of big laughing and enjoyment. It was the further case of the petitioner that after about a few minutes of taking charge, one unknown Assamese person came near the gate and informed him that he had come to meet Sanjay Dubey, Baljender Singh, and Constable Narendra Singh. The petitioner then informed the said person that these persons were in the mess oblique the cooking shed and asked him to wait so that he can give the message to the said persons. Thereupon, the petitioner went to the mess oblique the cooking hut, wherein he saw the said three persons, namely Sri Sanjay Dubey, Sri Bajinder Singh, and Constable Narendra Singh, were having liquor. Thereupon, it is the case of the petitioner that there were certain altercations which resulted there were certain altercations between the petitioner and the three persons, and the three persons came out of the cook shed, dragged the petitioner with his arms and ammunitions, and forcibly snatched away the arms, for which the petitioner and Sri Sanjay Dubey fell down on the ground, and in such scuffling, there was fired, and after that the arms were snatched by Sri Sanjay Dubey. Stop. It reveals that further from the records that the said departmental proceedings continue, wherein on behalf of the employer, on behalf of the, what do you say? Employer. On behalf of the employer, 5 witnesses were adduced. The statement of the petitioner was also taken. On the basis of the above, the learned inquiry officer came to the conclusion that all the three charges were proved against the petitioner. The petitioner thereupon was served the inquiry report and was given an opportunity to reply to the same. The petitioner accordingly replied to the same. It is further seen that by the order dated what is the date?
Appellate, my lord.
5/5/2009, taking into account that the charges have been duly proved, the respondent number 5 in exercise of the powers under Rule 32(1) read with Schedule 1 and Rule 32 Roman 1 of CISF Rules 2001, awarded the penalty of dismissal from service, which shall ordinarily be a disqualification for future employment under the government. Full stop. It was further mentioned that the suspension period from 4/10/2008 to 5/5/2009 will be treated as suspension and not on duty for the purpose. Further to that, it was also observed that the petitioner shall not get any other benefit other than the subsistence allowance which have already been paid to him during the period of suspension. The petitioner thereupon preferred an appeal against the said order, and the said appeal was dismissed by an order dated 18/7/2009, passed by the Deputy Inspector General, CISF Unit, ONGC Nazira. From a perusal of the said appellate order, it reveals that the appellate authority had duly taken note of that the principles of natural justice were duly complied with and had also discussed the findings arrived at by the inquiry officer on merits and found no reason to differ with the opinion of the inquiry officer. It further reveals from the record that the petitioner thereupon preferred an appeal revision before the revisional authority, which was also dismissed by an order dated 18/3/2010, holding inter alia that the charges leveled against the petitioner have been proved on the basis of evidence adduced before the inquiry officer during the course of the departmental inquiry. It was further held that the petitioner had been afforded all reasonable opportunity to defend himself, and there was no procedural irregularity in conducting the departmental inquiry by the inquiry officer and the disciplinary authority in dealing with the case of the petitioner. It was further held that the allegations of the charges proved against the petitioner are serious in nature and subversive to the force discipline. Further to that, it was also held that a penalty awarded by the disciplinary authority and confirmed by the appellate authority is well commensurate with the gravity of the proven act of the misconduct. Being aggrieved by the order of dismissal dated
May 2009.
5/2009, which have been confirmed by the first appellate authority, as well as the revisional authority. The instant writ petition was filed on 8th of August 2011. It reveals from the record that this court had issued notice on 24/8/2011 and there was an interim order passed that till the returnable date, if the petitioner have not been removed or evicted from the quarter allotted to him, the petitioner shall not be ousted, subject to the condition that he may abide by the terms and conditions and maintain discipline as may be imposed to the authority. It further reveals that this court, by an order dated 18/11/2011, issued rule. Was there any order was vacated?
Probably, my lord, they filed an IA.
It is however relevant also to take note of that by an order dated 23/7/2012, this court, taking into account that the petitioner have been dismissed from service pursuant to a departmental proceedings on serious charges of dereliction of duty, the petitioner cannot be permitted to retain the quarter allowed to him while allowed to retain the quarter allotted to him, and accordingly, the interim order dated 24/8/2011 was vacated. It has been submitted at the bar that the petitioner thereupon had vacated the quarter. The record further shows that the respondent numbers 1, 2, 3, 4, and 5 had filed a joint affidavit on 7th of December 2011. A perusal of the said affidavit shows that the same that the dismissal order, the appellate order, as well as the revisional order have been supported. Had filed an affidavit in opposition supporting the dismissal order, appellate order, as well as the revisional order. It was further mentioned that that the petitioner was granted due opportunity, and thereupon, after following the principles of natural justice and taking into account the matter in the entirety, the disciplinary authority have imposed the punishment by the order dated 5/5/2009. It was further mentioned that the appellate authority as well as the revisional authority have also duly taken note of the facts and have confirmed the findings of the inquiry officer. The learned counsel for the petitioner, Mr. H.K. Sharma, submitted that the petitioner herein that simultaneously along with the departmental proceedings, criminal proceedings were also initiated against the petitioner. In the departmental proceedings, what has been held to be proved against the petitioner has been negated by the court of the
Session court, man. Assistant session court, session judge Siddharth.
in
Sessions case number 35, bracket capital S, bracket close 2006, under section 307 IPC, read with section 27, arms act.
and as such, the entire proceedings, the entire departmental proceedings suffers from entire departmental proceedings, including the inquiry report, suffers from perversity. He submitted that the authorities concerned, the inquiry officer, as well as the appellate, as well as the revisional authority, did not take into consideration that there was no proof that the petitioner was under intoxication. That's as well as also that the petitioner had fired four rounds.
And my lord, regarding that injury, my lord, there was no medical report. That
Hmm?
Sanjay Dubey, he got that minor injury. There was no medical report.
The learned counsel further submitted that nothing was taken into consideration during the departmental proceedings as regards whether there was any injury so caused on the basis of any document, any materials. It is therefore the submission of the learned counsel that the departmental inquiry was carried out most perfunctorily, and in order to only make the petitioner a scapegoat. On the other hand, Mr. G. Pegu, appearing on behalf of the respondent, submitted that the fact-finding inquiry had, after duly taken into account the evidence, had given the findings to the effect that all the three charges leveled against the petitioner have been proved. This aspect of the matter has also been confirmed by the First Appellate Authority as well as the Revisional Authority by resorting to the facts in detail. The Learned Counsel therefore submitted that taking into account the exercise of jurisdiction, this court is presently, taking into account that this court is exercising a jurisdiction under Article 226 of the Constitution, the contours of the jurisdiction would be only limited in respect to look into the decision-making process. Insofar as to whether the same is arbitrary, unreasonable, perverse, as well as have caused manifest injustice to the petitioner. The Learned Counsel therefore submitted that in a recent judgment of the Supreme Court in the case of Union of India and others versus Constable Sunil Kumar, reported in 2023, 3 SCC 622, the Supreme Court had clearly laid down the contours of the jurisdiction under Article 226 in respect to departmental inquiries. Further to that, Mr. G. Pegu also submitted that the exoneration of the petitioner in the criminal case would have no nexus on the departmental inquiry, inasmuch as in the criminal case, the proof which is to be deduced is beyond reasonable doubt, whereas in the departmental proceedings, the same has to be taken into consideration on the basis of preponderance of probabilities. I've heard the learned counsels for the parties and have also perused the materials on record. As regards the procedure so followed in the departmental proceedings as well as also the departmental proceedings, it is seen that the petitioner was duly given all such opportunity, was duly given the opportunities for the purpose of defending his case. And as such, the procedures were adopted by the inquiry officer as well as the subsequent actions for the purpose of actions so taken by the disciplinary authority as well as the appellate authority as well as the appellate authority and the revisional authority cannot be called on into question as regards the procedure. The next question therefore arises as regards whether this court should interfere on the findings on merits arrived at by the inquiry officer, which have been upheld by the appellate authority as well as the revisional authority. This court would have duly gone through the departmental proceedings, the departmental inquiry report. And from the same, inquiry report, this court could not find any perversity in the findings in the findings so arrived at as regards the charges 1, 2, and 3. This court further, it is also relevant to take note of that the appellate authority as well as the revisional authority have also duly taken note of the evidence on record and had come to a finding that the inquiry proceedings so initiated, the findings of the inquiry officer was in conformity with the evidence so adduced. Now the question arises as regards the punishment so imposed. This court at this stage finds it relevant to quote, take note of the judgment of the Supreme Court in the case of Constable Sunil Kumar Supra, and more particularly to paragraph number 10, 11, 12, of the said judgment which is reproduced herein under. Taking into account the above proposition of law as laid down by the Supreme Court and applying the same to the facts of the instant case, wherein the charges so leveled against the petitioner which have been proved constitutes grave and serious misconduct. This court is of the opinion that the question of the opinion that there arises no question that the imposition of penalty, so imposition of the penalty of dismissal, being not disproportionate to the charges proved, does not arise. This court, before further taking into account the above, this court therefore finds no grounds to interfere with the order of dismissal dated 5/5/2009, as well as the appellate and the revisional orders dated so and so and so and so respectively. Accordingly, the petition therefore stands dismissed. Next, before parting with the record, this court, however, finds it relevant. Before parting with the record, this court further finds it relevant to take note of the submission made by the learned counsel for the petitioner that pursuant to the order dated
24/7/2008.
24/7/2008 passed in WPC number 2308/2004. The petitioner is entitled to the consequential benefits arising out of the setting aside of the order dated 3/7/2003. It is the respective submission of the petitioner, it is the specific submission of the petitioner, counsel for the petitioner, that for this period from 3rd of July 2003 till his reinstatement on 8
My lord,
on
4/10/2008.
on 4/10/2008, the petitioner had not been granted the benefits consequential benefits which ensures pursuant to the order dated 24/7/2008.
Sorry for interruption, my lord. As per our affidavit, my lord, paragraph 7, my lord, he has received the and taken the benefits, my lord.
I'm not saying. On the other hand, Mr. G. Pegu, appearing on behalf of the respondent, submits that the said amount has been, the said consequential benefits have already been granted, given to the petitioner. So, taking into account the above submissions, this court therefore directs the respondent number 5 to verify as to whether the petitioner have been granted the consequential benefits in pursuance to the judgment and order dated 24/7/2008 in WPC number 2308/2004 during the period from 3/7/2003 to 4/1/2008,
410 to the
4/10/2008. It is, this court further directs the respondent number 5 that in the event it is found that such consequential benefits have not been granted, the petitioner be granted the said benefits within a period of 60 days from the date a certified copy of the instant order is served upon the respondent number 5. With the above, in view of the above, the instant petition stands dismissed, save and except the observations made in paragraph number, hey, last paragraph 2, paragraph 2. Huh? Yeah, instant judgment.
They must have retired. I had
Must have
sweat.
retired long back, not now. Because I am for the private respondents. They were promoted subsequently because of vacation of the interim order. And they have already retired in the year 2013-14. They were at the verge of retirement because before the promotion was granted.
How do you say so?
I filed my affidavit in.
Have you stated that they have retired?
Yes, they are not, at that time, they were not retired.
Okay, well, wait. We have the list. Let us see from here. The provisional list of these persons who are the petitioners. Name, see the petitioner's name. We have 5 petitions. Basanto Medhi. Where is his name? We have the Basanto Medhi is 1956 born. He goes. Mr. Sharma, kindly come to page 15. The first petitioner is Basanto Medhi. Date of birth is 56. 56 today, he is no longer there. He's there, but he's no longer in service. Rams Ratneswar, 57, he also goes. Then Humeswar Medhi, 56, he goes. Dilip Das, 56, he goes. And remains is Mukul Kumar Rabha, 67. Now, what is his age would be? 30. 33 plus 23. 60.
56.
It'll be 60 years. Isn't it? Now, have these petitioners thereupon been granted? Who has filed the affidavit? I'll be respondent number 1.
The last petitioner lordship, probably his age is 56. 56
Hmm?
56 or 57 years lord.
Who?
The last one lordship, Mukul Rahal. He must be in service.
How? He's 67 born. If he's 67, that is 33 years from there to make it 2000 and plus 23 years here. It is
56.
56.
56.
33, 56 years.
Fine.
Mr. Bhagavati,
Lordship.
in page 38, that is annexure A to your affidavit.
Lordship, I don't know the doctor record. It was long back. They were promoted, they left it then and there.
Huh?
They were promoted because after vacation of the stay order, they were promoted and they left
Stay
their
order.
service and they have to leave me also. I do not have anything.
Stay positive. What's there?
Initially interim stays. There was a- some mistakes or because.
Stairs only.
For stay for promotion.
In this case, to pursue into
Stay for promotion. Stay for with.
Stay vacation.
I.
Yes.
So, Mr. Sharma, you are to show me that the departmental, you are not required to pass the departmental examination. Because the stand of the respondents is that as regards the petitioner number 1, 2, 3, these people have failed to pass. They are to pass in two exams. One is the civil engineering and the other is the accounts paper. You were appointed, the petition number 5 was appointed in 1992. He appeared for 4 times, he could not. So you have to show before this court that the departmental examination is not required to be passed, and then also it is required for him to be considered. Whereas the flood control rules,
11 rules.
Rule 11 says that has to requirement for a candidate for promotion from so-and-so as well as a subordinate who has successfully undergone the training and passed the departmental examination as prescribed by the government from time to time. So unless Rule 11 is not struck down, how do I give you an appointment? Hold that the actions of their part is wrong. Where is the rule?
It with me.
Earlier, Mr. A. Chakravarti has been burdened with a litigation which is also there, and now Mr. M.P. Sharma also comes. Mr. Sharma, because of you, I have removed this glass. Otherwise, very difficult to hear you. Tell me.
Lordship will kindly take it up tomorrow, Lordship. I shall come prepared.
He has successfully undergone the training and passed the departmental exam as prescribed by the government from time to time. What is there to prepare? This is what is there in Rule 11. You have failed to pass.
But then, Lordship, since 2002 till 2010, Lordship, I was deprived for not holding that examination.
No. There were many times it was held. You got 4 chances, the petitioner number 5. Petitioner 1, 2, and 3 have got 7 chances. You have not done it. Then you have failed so many times. The petitioners before this court have assailed the selection process dated 9/8/2011. Whereby various junior engineers in the water resource department were promoted to the post of assistant engineer. The petitioners have also sought for a direction upon the respondents to hold departmental examination in the rank of junior engineers for eligibility for consideration to the promotion to the post of assistant engineer in the water resource department, Government of Assam. Taking into account that it is the specific case of the petitioner, that they were not considered for the promotion from the post of the junior engineer to the post of the assistant engineer of the water resource department. This court finds it relevant to take note of Rule 11 of the Assam Engineering Flood Control Department Service Rules 1981. For short, the rules of 1981. The said rule, for the sake of convenience, is quoted here and below. You give a photocopy or you
Yes,
make this
we-
photo.
We have copies. Lord.
Huh?
We have copies.
So we can keep it.
Yes,
Yeah, look. From a perusal of Rule 3, Rule 4, a sub-rule 4 of Rule 11 of the rules of 1981, a member of a subordinate engineering grade 1 bracket flood control department service bracket service shall be eligible for promotion as assistant engineer subject to the following conditions. Subject to the conditions as enumerated in subclause A and B. The said conditions are that the said person have rendered minimum 8 years of service as a subordinate engineer as on 1st of January of the year of promotion. And secondly, that the said person had successfully undergone the training and passed the departmental examination as prescribed by the government from time to time. This court finds it relevant to take note of the affidavit in opposition filed by the respondent number 1. In the said affidavit in opposition, it has been mentioned that the departmental exams were held 7 times, that is in March 1987, November 1990, August 1991, September 1994, September 1995, February 1999, and lastly in January 2001. That is during the tenure of service of the present petitioners. It was further mentioned that except the petition number 3 and 4, other petitioners never appeared in the departmental examination. Further, it has been mentioned that the petitioner number 1 appeared in the departmental examination held on 24/11/1990 and passed in the paper of civil engineering only, and his results along with other declared by notification dated 18/6/1991, but he could not come out successful in the accounts paper. As regards the petitioner number 3, it has been mentioned that he appeared in the departmental examination held on 23/9/1995, wherein he had only cleared the civil engineering paper, but failed to be successful in the accounts paper. As regards the petitioner number 4, it was mentioned that he appeared in the departmental examination held on 7/2/1999 and passed in the paper of accounts only, but failed to pass the civil engineering paper. Further to that, it has been mentioned that the petitioner number 2, who was appointed in the year 1981, did not come out successful in any of the examination held 7 times for the reasons best known to him. As regards the petitioner number 5, it has been mentioned that after he had joined service in the year 1992, he got as many as 4 chances to clear his departmental examination, as during the period, departmental examinations were held 4 times, as explained therein above, and he was least bothered towards successful completion of his departmental examinations. This court cannot also lose sight of the fact that the petitioner number 1 to 4 have already retired from service. As regards the petitioner number 5, he is yet to retire in service, but it is not known as to whether the petitioner number 5 in the meantime has been granted any promotion or not. Be that as it may, taking into account that the eligibility and in terms with Rule 11, 11.4, for being considered for promotion to the post of assistant engineer, is that the person concerned has to render minimum 8 years of service and has to also undergo training and pass the departmental examination as prescribed by the government from time to time. This court, taking into account that the petitioner number 5 had joined in the year 1992, and he would be eligible only after 8 years, and also taking into account the stand so taken in the affidavit in opposition by the respondent number 1, that there has been no departmental examination held from 2002 to 2010. This court is of the opinion that as the eligibility of the petitioner number 5 only becomes eligible after 8 years of service, and thereupon not holding any departmental examination on the ground that there are sufficient members, sufficient candidates who have already passed departmental examination,
And also,
may affect.
and also during that period, no major recruitment process.
Understood, but after all,
Yes, yes.
and taking into account that no mention it here. Last time too. Sufficient employees, candidates who have passed the departmental examination, it is the opinion of this court that the right of the petitioner number 5 had only accrued after in the year 2010 or 2000 or 2001.
2001 birthday.
8 years, when are you going to complete? 2001.
Not.
In 2000. Now, upon completion of the 8 years, the non-holding of the departmental proceedings,
Not
the
proceeding.
departmental examination, would definitely affect the rights of promotion of the petitioner number 5. Taking into account that, above, it is therefore observed that if pursuant to 2011, there has been no departmental examination held, and the petitioner number 5 still continues to render service as an assistant engineer on the ground that the
No,
departmental,
Not assistant engineer, junior engineer.
as a junior engineer, on the ground that there is been no departmental examination so held. This court taking into account the mandate of Rule 11(4)(b), directs the respondent authorities to hold a departmental examination as required under section Rule 11(4)(b), so that the petitioner can, number 5, can be considered for promotion. The above direction is subject to the petitioner number 5 having not been promoted in the meantime. With the above, the instant petition stands disposed.
He will
I-
be 8 years, he will complete on 10/7/2000, Lord.
So that is why till 2001 they held it. Thereafter your right accrues. So thereafter, if it is not held, because they say that from 2002 to 2010 we have not held, and that is what is your prayer. So in the meantime, you have already been promoted, it is okay. But if it is not, I've directed them to hold the department so that you can be considered.
Because affidavit was filed during 2011-12.
Understood? But then also,
My lord, I am appearing for the state along with my land.
you
Like-
give your name, whoever.
Item number 5.
Lordship, in this matter, relates to the promotion of the petitioner. Lordship, what had happened, Lordship, a departmental proceeding was initiated against, not only one, Lordship, there were several departmental proceedings, proposed notices were served, but only one was proceeded with, and the penalty.
There is some judgment of Justice Surana.
Yes, yes.
Yes, Lordship.
What is this?
Lordship, we had challenged the penalty imposed upon us in that case, Lordship, and in that order, Lordship, the penalty was upheld, Lordship.
Then,
Then, Lordship, we have filed an appeal, and that appeal is still pending, Lord.
this order,
Against WBC number 1, yes.
139/2016. So the appeal is pending. Now, what is this matter about then?
This matter relates to the promotion of the petitioner from E6 to E7 grade, Lordship.
Huh?
Lordship, he was to be promoted in 2009 itself. Lordship, but then what had
Give
happened?
promotion to the post of general manager with retrospective effect from Iman from the date of recommendation in a deed in the nature directing the act to deposit the monthly salary of the petitioner from the month of so and so. Now, monthly salary of the petitioner for what?
Lordship, what had happened,
You
Lordship?
have not received the salary.
They transferred me to Delhi, Lordship, but there were cases filed and subsequently I had to join at Delhi, Lordship. And after that joining, although they released my salaries, Lordship, they did not consider my promotion, Lordship. And their ground was that, Lordship, since some vigilance inquiry was pending against me, Lordship, that could not be considered. The subsequent, that what vigilance inquiry was against me, that was not communicated at that point of time. I approached this honorable court, I filed 2-3 petitions, Lordship, and therein, Lordship, there was a direction to consider my representations, and those representations were being considered. After consideration of those, they had passed an order, Lordship, that is it's at page 41, Lordship. Therein they say that, Lordship, after the departmental disciplinary proceeding is concluded, Lordship, they will consider my promotion. But then, Lordship, in 2012, I retired. And subsequently, the departmental proceeding ended and the penalty order was imposed in 2013. And that was put to challenge in this WPC number 139 of 2016. And that this honorable single judge, Lordship, he did not interfere with the penalty order. Subsequently, it was brought up on appeal in writ appeal number 167 of 2020. That is still pending, Lordship. And in case that is being considered, Lordship, that readable lordship.
So you mean to say your promotion was withheld in view of the departmental proceedings?
Lordship.
And thereupon the departmental proceedings was decided against you, which was challenged in a writ petition before this court. And this court had upheld it, and now an appeal is pending.
Lordship.
So the prayer which is given out here as to give you retrospective promotion from that day can only be done only on the basis of a departmental proceedings being finalized.
Lordship.
Now, as of date, it is finalized. Whether there is a stay to it, no.
No,
So under such circumstances, can you now ask for this promotion
lordship, because
in view of the departmental proceedings having been decided against you?
lordship, that is there, but lordship, apparently what had happened, lordship, there was a committee being formed to,
Now you say that if the departmental proceeding is set aside by the appellate court,
lordship,
then in that case, you will be entitled to promotion,
lordship,
isn't it? But if it is not set aside, are you entitled to promotion? Tell me that.
no. No, lordship, but then lordship, they had in their, while considering my representation, lordship, in that communication itself, they have said that if the departmental proceeding is set aside, then they will promote me, lordship.
Understood.
Lordship.
So your promotion is dependent upon the departmental proceedings being set aside by the division bench.
Lordship.
Isn't it?
Yes, lordship.
Isn't it? So that is it. So as of now, the law, the whatever the present factual position which it stands, there's a departmental proceedings which goes against you. So under such circumstances, you cannot be promoted now.
Lordship, because the show cause itself was served after lordship my retirement. Yes, lordship, that was the case, lordship. In 2011, and prior to my retirement, lordship. After this exercise was undertaken, lordship. And this court was of that opinion, lordship, that lordship, the order is there.
Otherwise, you may say that the division bench tomorrow dismisses it, the appeal, you'll have a right to go to Supreme Court. So should we keep the matter pending till then?
Lordship. But then only thing, lordship.
Or
is that
can we say out
at that
here?
point of time.
No,
when
can we say, Mr. Sharma, that as it is the specific stand by them, that you would be granted promotion if the departmental proceedings are set aside or decided in your favor. If in the circumstance the departmental proceedings are set aside or the penalty is set aside, the respondent shall duly consider your case for the granting of the promotion. I think that is the best, well and well said.
Lordship, but this case was filed when he was in service, lordship.
Understood, but I'm understood. But can he now get it? You are asking for a retrospective promotion because you were entitled for the promotion then.
Right.
And there is a stand which has been taken by the respondent authority stating that your promotion shall be duly considered, subject to the outcome of the departmental proceedings. Now, as of now, the departmental proceedings is against you. This court has also held it against you. You have filed an appeal. Now, that appeal remains pending. But if in the circumstances the departmental proceedings is set aside, or the findings, the penalty is set aside, and you are being given the benefit thereof, or some other punishment is imposed, which is not there, then only your right of promotion will be there, or does your right of promotion
But
accrue?
actually, what penalty was imposed was that only 50,000 is to be deducted from me, and my promotion was not to be
So only 50%.
50,000 rupees token amount of money was to be deducted from me. Lordship.
And have they deducted that?
That has already been deducted. And that with respect to promotion, Lordship, they have nothing held against.
Let us see where they say what is the outcome. And what was the penalty imposed?
Lordship,
Not only the penalty, what has been the departmental proceedings, what do they say?
Lordship,
Let us see that order by which promotion to be made to you.
Lordship. Page 43, Lordship, may kindly turn to.
43, yes.
In view of the above facts and circumstances, and as per the decision of the Director of Boards, the offer of appointment for the post of General Manager at E7 level can only be issued after completion of the departmental proceeding and subject to fully exoneration of the charges leveled against you in the aforesaid charge sheets. Accordingly, your above representation are disposed of in pursuance to the orders dated 25/8/2011 and 39/2011 of the Honorable High Court of Guwahati in respect of the above written. That was the
So this is regarding fully exoneration. You have not been fully exonerated. Have you? There's the imposition of a penalty.
there were many show cause notices, Lordship, and
Huh?
there were many, Lordship. In fact, in this case also, Lordship, what had happened, Lordship, the facts are like this, Lordship. Cement bags were to be transported from here to Imphal. At that point of time, Lordship, there was terrorist activities, and what had happened during transportation, some rain and other factors were also there. The cement bags could not be downloaded at that point of time at Imphal, and there were chances of that cement bags getting damaged.
Mr. Sharma, I understand.
Lord.
You may have a very good case, but the coordinate bench have already decided against you. I'm not on that.
Lordship.
Now, the fact is whether you will be entitled to promotion unless you are fully exonerated.
That matter is still pending, Lordship. So
So they'll have to take a call if you are exonerated. Otherwise, what is the point in keeping the matter pending? Isn't it?
Lordship will take this matter along with that because that matter is to be decided, Lordship.
Huh?
That departmental penalty imposed against me, Lordship. That is pending and it is to be decided at some point of time, Lordship.
I can take this with that. There's no problem with that. But the problem is this. The only thing is, wouldn't this help you? If I say that subject to full exoneration, if the departmental proceedings which has been decided on the penalty so imposed upon you is set aside, then in that case, the authorities shall duly take note of and pass appropriate orders.
Lordship, that I can't say, but Lordship, per se, that penalty was illegal, Lordship, and since a committee
I
already.
can't
sat
say
over-
that it is legal because of a coordinate
it's
bench
still-
having already said to be illegal.
Lordship. There was a committee being set up for that, Lordship, whether my non-invocation of the clause was arbitrary or not. And that committee.
This court can look into this now. As of now, you make this argument if I am sitting ever in division bench.
I understand.
But as of
Lordship,
now,
my
that can't be.
simple prayer would be, Lordship, since that matter is pending, Lordship, it may be taken along with that.
So we take this matter with that. The instant petition has been filed by the petitioner, seeking a direction upon the respondent authorities to give him promotion to the post of general manager with retrospective effect from 29/6/2009. From the date he was recommended for promotion. It is relevant to take note of that when the petition was filed, the age of the petitioner was 58, and as such, the petitioner 58. Because In the meantime, as submitted by Mr. MP Sharma, the learned counsel for the petitioner, the petitioner had retired in the year 2012.
29 to
You-
2012.
During the course of hearing, a document was shown, which is a part of annexure G to the writ petition, wherein it has been mentioned that the question of promotion to the petitioner shall be dependent upon full exoneration of the charges leveled against him in the charge sheet. Next. It further transpires that in the said departmental inquiry, the inquiry officer, the authorities concerned, the disciplinary authority had arrived at a finding that the petitioner that the charges against the petitioner have been proved, and accordingly imposed an amount of rupees 50,000 to be deducted from the petitioner's dues. The said penalty so imposed was challenged before this court in WPC number 139/2016. And this court, by the order date, the judgment and order dated 16/7/2009, upheld the penalty so imposed. The learned counsel for the petitioner, Mr. MP Sharma, further submits that there is a challenge to the said judgment and order dated 16/7/2019, passed in WPC number 139/2016. In writ appeal number
167 of 2020.
167/2020. He submitted that in the eventuality, the writ appeal is decided in the favor of the petitioner, the petitioner would be entitled to those benefits of promotion. And as such, the instant writ petition be tagged along with writ appeal number
67 of 2020.
so and so, taking into account that the findings that the result of the writ appeal would have a bearing on the reliefs, on the bearing on the instant writ petition. Taking into account, upon hearing the learned counsel and perusal of the materials on record, this court also finds that the submission of Mr. MP Sharma, the learned counsel for the petitioner, to be reasonable and substantive. And accordingly, this court directs the registry to list the instant writ appeal, this writ petition, along with writ appeal number so and so.
Lordship has written it as dues, Lordship. Therein in the order, it appears as retirement benefits. Lordship, that recovery of rupees 50,000 from Lordship has written it as dues probably, Lordship, and in the order, Lordship, it appears as retirement benefits.
From your dues, are retirement benefits not your dues?
Sure.
That is why I have said only dues. I have not said from your earlier amount.
Sure.
I've said it specifically dues because of this. It's not clear whether it is retirement of anything. Go and fight it out before the High Court division bench.
Obliged, Lordship. Lordship, can a date be given, Lordship?
How can I fix?
I'm obliged, Lordship. I understand.
It is, you are asking, if I give you something, doesn't mean that you'll go and ask for the moon. That-
Item number 6 for admission.
Yes, Mr. Ahmed. I didn't disturb you in the earlier matter. Now the thing arises. Tell me, how can you keep that amount for a particular period by not and return it without payment of interest?
I'll have to go into the clauses of the agreement.
No, the agreement doesn't say so. First of all, as per clause 4.2, you have you say that you are going to give them an inspection.
Yes.
As per clause 11.8, you say that you cannot refuse once you have submitted to the bid. Meaning thereby, the goods are there for inspection. Now, can you take a plea now? Then look here. They have participated. Meaning thereby they have already looked into it. And now you say that no, we don't have the materials. Then why do you take the money at first? And why did you at best? Okay, let them be the sales certificate. One has to deposit this 7% or the amount only when you issue the sales certificate. Why did you issue the sales certificate if you didn't have the coal with you?
11.7.
Isn't that your case?
Which is not her case. Lordship has made out a case for them. Your lordship has made out a case for them.
That's my prayer, Father.
11.7.
No, she is asking the money because of that.
11.7.
Your lordship, first of all,
And that is why on that day I didn't dispose of the matter. I gave you a chance as I had made the case for them.
it's in the I'll have to go through some of the clauses. And before that, your lordship, I may submit that the petitioner is not new. A regular buyer.
Absolutely understandable.
In
Only
fact,
thing is, if you didn't have the materials, why did you issue the sales certificate? I'm only on that.
they could have opposed at that stage only.
How, can you oppose in view
Yes.
of 11.8? They can't oppose then. They can't oppose anything. Once they participate and you hold them that these are the 5 or 6 or 10 bidders who are successful. The moment they issue the sales certificate, duty is cast upon them to make the payment. Else the earnest money deposit will be forfeited. So under such circumstances, they deposit the money. Why did you issue the sales certificate if you didn't have the stock?
The sales certificate, your lordship, 11.2 states that all terms and conditions of the scheme are subject to force majeure conditions as applicable. It's at page 30.
All terms and conditions are subject to force majeure conditions as applicable. Now, are you saying that you had the coal, then something has happened? Then only the force majeure will come. The force majeure would otherwise not come. Or is it only for the first time it has happened?
No,
Force majeure, it can't be on a regular phenomena. It can't be. If it is a regular phenomena, it can't be a force majeure.
continuing की होगा continue. Billing line
11.7.
Clause 11.7 states that quantity mentioned in notice are only indicative and may undergo a change depending on factors.
Absolutely, Mr. Ahmed.
Yes,
Mr. Ahmed, there is no quarrel. The notice is you are referring to the notice of e-auction.
Yes. And then.
I'm not on that. Yes, it may depend. At that point of, as you have submitted that we issue a notice inviting auctions saying that this is the procurement amount of, just for example, 10,000, 11,000, 3 lakh. This is the amount which we are thinking will be produced.
Will produce.
And accordingly, we issue this. People submit their tenders. No problem. Thereupon, when you issue the sales certificate, duty is cast upon the other side to make the payment, else the EMD would be forfeited.
That is. that
Now,
is the-
why did you issue the sales certificate without having the code?
With the sales certificate will go. Sales certificate.
Sales certificate was given.
Page 33, my lord, intimation, sale intimation letter.
Huh?
No,
Page
there is no
33,
sales
sale
certificate.
intimation letter.
Only 2 rakes only.
Show me, on what basis?
The 7 days time starts from this letter.
Of page 31.
Page 33 also, my lord, and page.
This is it. I'm saying sale intimation letter.
Intimation.
So this letter, why did you give it? And from there, the 7 days start? Giving the quantity, you have to allow them. And then you take the money and refund it as per your wish. What will happen to the interest? How much should be the regular interest? 12%? 15?
I don't know, 12% minimum.
15?
12% is what they have claimed, but Your Worship, I still submit. They were aware that it could be possible in certain conditions, certain weather conditions, or otherwise, sometimes the coal does not come to the depot. And
Is it only for this instance or every time?
no, only here, 1 or 2 occasions earlier also it has happened.
Monsoon time.
Now, are you saying in your affidavit that after the sales certificate was issued, whereby the petitioners were directed to deposit, that these factors came into happen, or was it before that?
No.
If it was before that, you couldn't have.
No, no.
After that only it could have been.
Our affidavit at paragraph 6, page 3. Has Roshu got it? Yet I further state that similarly in the auction dated 28/6/2013, out of 5 rakes booked, the first 3 rakes as per the seniority in the bid list were dispatched and full coal value deposited against the balance 2 rakes, which could not be loaded owing to constraints like continuous heavy rainfall, resulting in less production, have been refunded to the parties. In that particular auction, the petitioner also participated and was successful. So there is no basis of complaint.
No. You see, what is it? Kindly see, which could not be loaded owing to constraint like continuous heavy rainfall resulting in less production. It is on the question of less production. meaning thereby you
Coal was
could
not
not
there.
produce.
So what happens?
But how did you issue the sales certificate without having the quantity with you? And how do they inspect then? How do you bring 4.2 and 11.8 together then?
Worship is a process where coal keeps coming from the colliery onto the loading point. We have a dumping site where the coal is kept in every rail yard. And we estimate in a particular month, this is the amount of production will there. On that basis, we give the advertisement, call for tender for this much coal. And we have said that it may not be possible to give the entire.
Mr. Ahmed, I'm absolutely in agreement till then. You may say tomorrow that they have participated in this tender, and this tender, we have no production on this thing. But you have issued a sale intimation on the basis of which the clock starts, where they within 7 days have to deposit. And if they don't, you take away the EMD. How do you take care of that situation? And then you say that the production was less. How can there be a production of less, taking into account that they have a right to inspect under 4.2?
Your Worship is correct there that perhaps that anomaly is there in the agreement itself.
Are you saying that the scheme is bad?
No, I won't say it's bad. It's been functioning otherwise without any problem all over the country. Indeed. Every state we are conducting this particular kind of sale under this.
Understood, but you only gave her 2 racks
Yes.
out of the 5.
This is only about 20% of the production, total production, which we give for open sale. That is what is given now under the spot auction sale. And that was done only after the smokeless fuel case. Supreme Court had directed that he make out the scheme. Let there be transparency. That is why the scheme came in 2007. Now till 2024, we are still continuing with the scheme. No problems otherwise. Even the petitioner, 5 days after not getting the coal in this particular batch, obtained coal in the next batch.
No, petitioner is in the business of doing it, so petitioner will continue to do so.
And what happens?
But this case
allegation
would help the petitioner in future and also alarm the Coal India in future that they should do something. Think about it. Don't issue the sales certificate unless and until you have the coal with you. You can't do that. Because you see, if you read 4.2, 11.8, then 9, how can you do that?
And the other clauses also. 11.9, your Lordship will see notice in coal fields, and then the MSTC Limited and M Junction, who are the service providers,
Reserve the right to
reserve the
cancel
right to
the
cancel
sale
the
of
sale of
coal
coal.
under this auction from any source, location in part
or whole
or whole at any stage at its sole discretion,
without
without
assigning.
assigning any reasons thereof, and no party shall have any right to raise any claim in that regard on that account.
And then 11.10 also, you have the right to amend, modify, and revise the terms and conditions. And then each sale in every e-auction is a complete transaction. We cannot carry forward.
Hmm? But Tell me, once you issue the sale certificate and the moment the payment has been made, is the sale not complete?
No, until the coal is delivered, until the coal is delivered at the delivery point, there cannot be any sale.
The sale is not complete.
No. Yeah, delivery fully-
As per the Sale of Goods Act, what happens?
My lord, here, since the poll is already there, and as my lord has already taken note of clause 4.2, we are also given for inspection. And once we inspect, we pay the money, sale is complete, my lord. It's only the delivery part is concerned. That is that is only the delivery dispatch part. Sale becomes
No, no,
complete, my
in
lord.
respect of an immovable property,
My-
movable property,
my-
this soul is movable.
My
Movable property, when is a sale complete?
my lord.
Is it on the basis of delivery of possession or not?
My lord, no, my lord. Otherwise, that EMD forfeiture will not apply. If the coal is there, I paid the money, and they see you did not lift it. That is lifting and dispatching. The sale was complete. I did not lift it, so I need to suffer in that other case that.
No,
EMD was
understood.
completed,
No, no,
My lord.
I'm not on that.
I
I'm
want-
only on this, that if the sale is not complete, they have a right to cancel the sale.
My lord.
You see
My lord,
11.9.
Cancellation will be, my lord, before that sale intimation letter, they.
No,
not
therefore,
even-
I'm saying whether the sale intimation letter read with this particular payment being received, would it complete the sale
In my-
or is it only upon delivery of possession?
My lord, in respect, in my humble submission, my lord, the sale will be complete once they issue the sale intimation letter and my payment is accepted by them, sale is complete. Either I lift it or not lift it, the sale is complete for them. If I don't lift it, they will forfeit my EMD. And it is precisely that reason why this 4.2, the EMD forfeiture clause is there.
Okay, so you say that if you within 45 days you don't lift it, then in that regard, there will be a forfeiture.
There will be a forfeit.
And as such, in view of this 45 days, the period starts after making payment,
Yes.
so the sale is complete.
Starts from the sale intimation letter itself.
Again, you're saying sale intimation letter, where is it?
So sale intimation letter, 7 days you make the payment, and if you don't thereupon lift it,
Yes,
so therefore, it is not, the sale is complete, the burden is upon you to lift.
exactly.
Meaning that if the burden is upon you to lift, it is, the possession has already been delivered.
Exactly, my lord, deemed possession.
Yeah. Right.
Lordship has raised a- Your Lordship has raised a question which is creating some problems. As far as, then we'll have to go into sale of goods act. What is,
No, understood. But who is to lift it?
lifting is this.
So how do you lift it if there is no delivery of possession?
For that purpose, like, again have to go back to the earlier clause where they say, it is said that they have to inspect it coal. At the time of inspection, if they see there is no coal, how do they proceed? They have a right to refuse.
That they have a right to refuse. But the fact that they have submitted,
No, they
no,
submitted.
the fact that they have submitted, that there was a coal, and you have accepted on that e-auction and have it taken up the steps, wouldn't that presuppose that you had the coal?
It works both ways, Your Lordship. That is presumption. That
No, there's no
says-
presumption. The presumption is, there are three presumptions. The first presumption is there is coal which they have inspected,
Yes.
and on the basis of which they have submitted the e-auction.
Submitted their bid.
That's a presumption which is there. The moment, because of clause 4.2. Clause 11.8 says that if you don't, you cannot later on say, in law 4.2, you cannot later on say that, look here, I'm not going to lift it because the quantity or the quality is not bad, good. Meaning thereby, 4.2 has to be consequential to 11.8. Now you issue a sale intimation letter and they are to pay within 7 days. The sale intimation letter presupposes that you have the goods. Otherwise, you don't sell something which is not intangible. Then she purchases it, pays you the money. Then the next presumption is you have already paid this money, and as such, if you don't live within 45 days, you lose your EMD. Which again presupposes the fact that materials have been delivered to her for the purpose of lifting, because the burden is upon her. These are all presupposes, but it is on the basis of deemed as per the provisions.
This is where 4.2.
Mr. Ahmed, she's a regular here, so kindly try to settle it out with her. Because otherwise this court is going to pass an order. And if this court passes an order, you may have further litigations all along. It may be good for the lawyer, but not for the client.
They're not losers in this business.
Huh?
They're not losers in this business.
Because this is what it is. It presupposes this. You are entitled to pay something. You are liable to pay something for the
You don't
interest
have
because
to
you
note
have
that
not.
case.
Because it amounts to a breach of contract.
Well, presupposing.
But the other thing is, the breach of contract is there, but if it is a breach of contract where the fact that you have received, the fact that you have refunded, being matters of already established, there's no denial to that effect. There's no question of any alternative remedy be gone into.
Here, arbitration provision is there, they have not gone there. Arbitration clauses there in the,
But have you raised that issue in your petition affidavit?
we have not raised because there are hundreds of petitions.
No, if you have not raised it, then obviously you have not exercised what is required under the Arbitration and Conciliation Act.
Laws to- if you will-
Okay, Mr. Ahmed, we'll hear you again, not today. Or when? 17th? Because I won't keep you after 2 unnecessarily. This is the matter again on 17th for further consideration. In the meantime, try to settle out.
Grateful, ma'am.
And you put again.
Concluded contract. Concluded contract.
So you failed to submit, that is the reason why.
Yes.
Paragraph 11 also, fail to submit that.
Why? You didn't have the challenge?
Okay, I had the challenge copy of the
Why
challenge.
didn't you submit along with it?
I had submitted along with my written submission and the lordship, I had submitted to, I had submitted and I'm ready to submit lordship in case. it has
Ready
not
to
been
submit is a different thing, but why didn't you submit at
lordship,
that
I
point
had
of time?
submitted along with
Where is
the,
your written submission? Written submission is at page 60.
lordship, page 61.
61. Where is it? You have mentioned that you have submitted.
Wherein 4 numbers of challans amounted to copy of challans are enclosed for your kind consideration.
Where?
Paragraph 2, Lordship.
And that's why in my adjudication order issued by so and so as pre-deposit of so and so, rest amount has been paid by 4 challan. Copies of the are enclosed for your kind consideration.
Lordship, the challans are, Lordship, there. Page 56, the copies of challans are there. Page 56, 57, 58, 59. These 4 challans are there, which totals to, Lordship. And these challans are apart from the pre-deposit.
When did you submit this?
Lordship, 2/3/2020.
21/3/2020.
Lordship, 2/3.
Paragraph 5, Lord, we have
2/3.
But you submit your written submission only on 21/3.
So the 2/3, Lordship, it's not
Oh,
21, it's
2/3.
2/3.
You are supposed to submit on when?
Lordship, I have to, appear.
As per your personal hearing?
Lordship, 27 to 80. 27 to 2020.
20/2/2023. 20.
Lordship, but I have.
Why
been-
did you submit so late?
Lordship, along with that, Lordship, it is written that please submit form in case of any other date and time of personal hearing is desired. So we had opted for 2/3/2020.
No, here it says if the declarant does not agree with the estimated amount payable as determined by the designated committee, he is requested to appear for personal hearing before the designated committee on so and so at GST Bhavan to explain the reasons thereof. Please submit so and so in case any other date and time of personal hearing is desired.
Lordship, that. I
Now,
had
did you
submitted.
do so? You submitted this
Yes, yes.
and stated what date was desired by you?
Yes, Your Lordship, at page 53.
That
I had stated-
indicate a preferred date of hearing is 27/2/2020.
I had indicated, Lordship, on 27 to 2020, I visited, but then Lordship, the person was not present, so we had filed the written submission before him.
But
along
you
with the-
didn't submit, your written submission is on 2/3.
Lordship, this, in fact, along with this form SPLDS 2A also, I have submitted my challan. Along with this,
Understood, but whatever may be, challan number one,
this
one PDF,
copy of challan in PDF, Lordship, I had submitted. along
only
with-
one.
Lordship, there was one PDF of the four challans which.
How do I know all 4 were there? It doesn't show anything to the effect.
Lordship,
Only
this is-
one PDF is
this
one
is the-
document.
This is the problem with the Lordship.
No.
internet.
Are you saying that all these documents, these documents is what? 1,14,078,
Copy of the.
1
challans.
lakh. These are the 2 challans you have given.
These are the 4 challans, Lordship.
Where are the 4 challans?
Lordship, 4 challans are at page 56, 57, 58, and 59. There are 4 challans.
So these were the amounts you have deposited, this 30 lakhs,
3 lakhs, Lordship.
3 lakhs 9,000,
Yes, Your Lordship.
8 lakhs 46,000,
Yes, Your Lordship.
and these are the amounts. And these were
1,000.
not shown out there, not taken into account in which document, if we see SDR 2,
Lordship,
in which year this was not taken into account?
Lordship, I'll show Lordship in the pre-deposit column. Lordship, may I kindly see pre-deposit, other deposit of duty.
Hmm,
It is written 23,67,000.
What was not taken into account, in which year it was not taken into account?
2013-14, Lordship.
14 is where,
Lordship, will find in my SVL there is one form. The year is 13-14. Lordship, will file order in original, Lordship, that 4th column from the left. Order in original. This is 13, Commissioner Guwahati, 13-14. These are 13-14.
so here you say that you have deposited for this particular erection and commissioning and installation service,
Hmm.
77 lakhs.
This is the.
Against that
demand.
23 lakhs have been shown and 36 lakhs or 38 lakhs
38 lakhs, Lordship, pre-deposit.
was
Lordship.
not shown.
Yes, Your Lordship. 36,95,674 is my deposit. Pre-deposit, they have taken it as 23,57,000. I'm saying I have deposited 13 more lakhs. So for that, I have given the copy of the challans that has not been.
13 more lakhs will be 36,000 lakhs.
Yes, your lordship, 36
What is this 38 lakhs? 38 lakhs or
36
36?
lakhs.
That is why I'm saying
lordship, 36 lakhs 95,674.
36, na?
36,
Yeah,
95,
that is why.
675. Yeah.
Hmm. Yes, what do you have to say?
Lordship, paragraph 5.
I'll read it.
Lordship, last 4 lines.
Absolutely.
Although the said petitioner in their submission
That
received
they did not submit.
by, they have stated the additional amount of rupees 13,27,714 was
Paid it
paid.
4 challans, but they
Full,
failed to
but they
submit
failed
any
to submit
proof
any
of that
proof
said
of that
payment and
amount
was invariably
invariably
relatable to the said
pending.
litigation.
This is the stand of it.
Yeah. Then,
Now, Lordship, the scheme is over, Lordship. There is no designated committee also.
huh?
There is no designation committee to consider the case of the petitioner as on date, Lordship. Unless it is revived. But we are in difficult to,
There is a notification on 17th of March 2021. Because lordship, all over India, there were a lot of litigations going on.
Hmm.
So even though it is online, it is, but manual processing is already there. Lordship, I have annexed it, lordship, at the last page, 104, in my paper book. A paper book which I have submitted is a 17th March 2021, because all over India, lordship, these litigations were going on. And lordship, what had happened because of the COVID period, lots of problems had arisen. So there were judgments on from various part of the countries, either to process the SVLDRS 1, or there were mistakes in SVLDRS 2. So they were allowed to lordship reconcile all the things.
this
So
is the document, 17th of March 2021.
yes, your lordship, manual
So
processing.
this will be done through whom?
Lordship, this principal commissioner, lordship, it has been given to the
In
principal
this regard,
commissioner.
it is to inform that the OCA have expressed an inability in providing the favor for electronic processing of the subject declaration matters in examining the court. It is hereby clarified that henceforth all references for count of approval of manual processing of declaration and made to the court, and such cases can be processed manually by the concerned designated upon fulfillment of the order of the High Court has been accepted by the concerned commissioner. Where given to the case and put out that I accept the sale of the order. All such declarations have been processed manually. May be reported to the one by of the court. Now you are saying that there is no designated authority.
Lordship.
Now what happens to all these matters where there has been certain illegality committed by the authorities by not taking into account certain things which were already there?
Lordship, in the lordship, similar circumstances, lordship, I have annexed.
When was the order passed?
Lordship, the order was passed
2020 December.
December 2020, second.
Hmm?
December 2020.
2 December 2020.
And why have you approached in 2021?
Lordship, I approached in 22nd of December 2020. I filed on 22nd of December. It got numbered in the next year.
Understood. Now, why this matter was, your order was of cancellation was given when?
2nd of December 2020.
No,
I
no.
approached with
Cancellation, this hearing happened on that day. When was the order of cancellation given?
lordship. It's very difficult to understand but because lordship, it is not communicated to us. It's just on the net when on page 60, lordship, I have received this.
No. You ought to have looked into it. Reasonable diligence on being found that the declaration is incorrect declaration, the designator rejected the storage.
Second December.
Hmm. When did you decide?
If,
From this form only, I came to know about the passing of the order and page 60, and I filed the page 60.
What did the Bombay High Court do?
Lordship, the Jharkhand Ranchi and the Bombay High Court, Lordship Munish Ranjan,
Lordship, because there was a, instead of writing the SPLDRS one form under litigation category, they filed the form under area category, and that is why it was dismissed. So that is the only difference, mistake that the petitioner did in this case, Munish Ranjan Mahajan. And finally, Lordship, the High Court, Lordship, decided that 2 weeks time was granted to make the payment. Lordship, this Sekar Poddar, Lordship, the judgment of the Supreme Court which has been passed. Lordship, the first judgment which I have next, which Jharkhand.
Now,
This
let us go by this thing. Whether these challans are challans which would enhance the total pre-deposit to 36 lakhs. You have held it to be 23 lakhs in your SDVL2 or something. But whether if these challans are taken note of, would it constitute 36 lakhs? Then this court can very well give a direction that if that is the information instruction we get it from you, then in that regard, this court can very well direct that remaining amount shall be paid by them and matter will end, which the Bombay High Court did.
But Lordship, the order I submitted before Lordship.
That is a thing where a person had to apply within a particular period. He has not done so. This is not the case out here.
Yes.
Here they have duly applied within the period. The only thing is they say that you have to pay 57 lakhs. They say that 57 lakhs you have done it on the basis of taking only pre-deposit of 23 lakhs, which you ought to have taken as 36 lakhs. And these are the challans so and so. You say that these challans were not at all deposited.
Not produced before the authority for consideration.
For consideration.
Yes.
But therefore, if we look into it as to whether the challans would constitute, if taken into consideration for that relevant period,
Yes, sir.
would be amount to 36 lakh,
Okay.
then the said decision can be very well interfered with. I need not send it to the designated authority and direct them to pay the remaining amount within a particular period. I think that is the best solution you have, because this court now can't send it and form a designated committee.
In some other cases, not relating to this scheme, this honorable court also extended, some committee was there, the term was expired. And this honorable court come to a finding that some mistake has been committed by the department. So unless that committee is revived, probably also can revive that committee also for particular.
That won't be proper, because you see a designated committee has been held on the basis of a particular thing.
Yes, sir.
Now, these designated committee consist of which are the officers?
Lordship,
Whoever it
yes,
is.
sir.
You take just your instructions on that and file an affidavit. Whether these 13 lakhs, if taken, could be the challans for the purpose of the year by which it is. Because then what happens now? The SDL VLR2, which has been given to her, on the face of it would be wrong.
Yes, sir.
And if it is wrong out there, then this court can very well direct that the remaining, the rejection is wrong and as such direct for making payment of only the remaining. But on the other hand, if these 30 lakhs were never there,
Yes, that question would have been different.
then obviously this court would not exercise the jurisdiction.
Yes, Lordship, that is.
I think that is the most pragmatic way by which the matter can be resolved. Because if I go direct now for the designated, it will lead to formation of the designated, which is beyond the purview now.
Yes,
As of now, the designated committee does not survive. So you are to only look into as to whether if these challans form actually a part of this and there was any mistake, if these challans were taken into consideration, the amount would be 23 lakhs or 36 lakhs. That's all.
if there may be another problem.
Mm.
If I have to file a fresh affidavit, then unless that committee is there. If
No. You don't need the committee. Who has filed the affidavit now?
Lordship, probably commissioner, principal commissioner has to file.
So let him consider this as to whether for that period, if these challans are taken into consideration, would it constitute that the deposit so made was actually 36 lakhs and not 23 lakhs?
I'll do.
If that is then the decision of the SDL or issuance of this would be wrong. And as such, this court can very well direct them to deposit within a period of 2 weeks or something, and then matter will end.
The principal commissioner was the heading the designated.
Whoever it is.
So I'll.
You take your decision who were there, but just file an affidavit as to whether if these ought to have been taken into consideration.
Right.
I think, madam, that would be the best way,
I'll be.
because that is what the Bombay High Court did. Because otherwise unnecessarily appointing or extending a period, I think that would be a bit outreach by this court under 226.
Recently in Supreme Court, in case of where effects were different, the petitioner was IBC proceeding was continuing. So under section 14, all the proceedings becomes stayed during the pendency of the IBC. Then the High Court rejected. Then the petitioner came to Supreme Court. Supreme Court says that because they were legally disabled, as such they could not file deposit their amount. So court has extended time and they were directed the department to accept their money loan.
No, it's okay, but I think this way, I think that
this
can
will
be
solve the
resolved.
problem.
I'll pass a detailed order, I think, which will may help you to file your affidavit.
Okay, it will not make any difference, but Sekar Resorts Limited has been also been, the judgment has also been given by Mr. Justice MR Shah only, who gave the judgment to
Not
Yasir Dutta.
necessary. We will look into it.
Same person.
We will now look into it later on. Yeah. The issue involved in the instant petition pertains to the rejection of the benefit under the Sabka Vikas (legacy dispute resolution scheme 2019. The rejection of the application of the petitioner under the Sabka Vikas
Viswas.
legacy dispute resolution scheme 2019. It appears from the records. It appears from the said scheme. Which is a part of the Finance Act 1994. Finance Act 1994.
Land Sec- Lordship.
1994.
2017.
Huh?
Lordship, 2019.
Finance Act 2019.
Yes.
That the same scheme visualizes a provision that is section 124. Whereby relief was available to the declarant under the said scheme where the tax dues are relatable to a show cause notice or one or more appeals arising out of the such notice, which is pending as on 30th of June 2019. And if the amount of duty is more than 50 lakhs, then 50% of the tax dues. It further appears from the records that the Government of India Ministry of Finance, Department of Revenue had issued a notification number 5/2019, Central Excise NT, dated 21/8/2019, whereby it was mentioned in clause 3 that a declaration under section 125 shall be made electronically at https://cbic-gst.gov.in in form SVLRDS-1 by the declarant on or before 31st of December 2019. The learned counsel, appearing on behalf of the petitioner, Ms. N. Hawalia, submits that the said period was further extended till 15/1/2020.
Provide notification number 7 of 2019.
7 of 2007,
7 of 2019.
dated,
Lordship, by notification number dated 31st December 2019.
dated 31st December. Be that as it may, the petitioner submitted its form SVLRDS-1 on 26/12/2019, wherein in respect to wherein various appeal proceedings, details of various appeal proceedings were mentioned. Relevant, however, is to take note of that in service tax /75975/2014, which pertain to duty/tax/cess for erection, commissioning, and installation service of an amount of rupees 77,03433. It was mentioned that there has been a pre-deposit /any other deposit of duty of an amount of rupees 36,95,674. 674?
Yes, sir.
Those of you, I think we need to have a magnifying glass. Okay. Full stop. Pursuant to the submission of the said declaration in form SVLDRS-1, the designated committee did not accept the said amount, said declaration, as could be seen from the records, in as much as the form number SVLDRS-3 was not issued. However, the designated authority issued a form number SVL-DRS-2, wherein in respect to the said appeal, above mentioned, the pre-deposit oblique any other deposit of duty as claimed to be 36,95,674. 6 or 8? 874.
74.
Huh?
674.
674 was stated to be or was ascertained as rupees 26,67,980.
Lordship, 2367,960.
Oh, 96. Okay.
2367.
And accordingly, the amount which was held to be payable by the petitioner was 57,68,277 and 50 paisa and 5 paisa only. In the said form number SPL-DRS-2, a notice of personal hearing was also given to the petitioner, stating inter alia that if the petitioner who was the declarant is not agreeable with the estimated amount payable as determined by the designated committee, the petitioner was requested to appear for personal hearing before the designated committee on 20/2/2020 at 11:30 a.m. at the GST Bhavan, Guwahati, to explain the reasons thereof. Further to that, it was also mentioned that if the petitioner wanted any other date and time of personal hearing, he may submit, the petitioner may submit SVL-DRS-2A. It reveals from the records from the said form number SVL-RDS-2 that the designated committee consisted of the principal commissioner as well as the joint commissioner. The records further reveal that the petitioner submitted the form number SVL-DRS-2A, wherein a copy of a challan was enclosed, uploaded in PDF format, and the indicated date of preferred hearing was fixed on 27/2/2020. It further reveals that the petitioner thereupon submitted a written submission in lieu of personal hearing on personal hearing, which was received by the office of the commissioner. Commissioner?
Principal Commissioner.
Principal commissioner or what? You people.
Lordship, Commissioner, it is written Commissioner only.
Commissioner, Central Goods and Service Tax, Guwahati, on 2/3/2020. From a perusal of the said written submission, it appears that the only issue which the petitioner had was that an amount of 13,27,714, which was paid by 4 challans, were not taken into consideration while considering the pre-deposit so paid by the petitioner. It further appears from the contents of the said written submission that the copies of the said challans were enclosed for the consideration of the designated committee. Thereupon, it is the case of the petitioner that in the month of December 2020, the petitioner came to learn that their application under the above mentioned scheme was rejected. And as such, the present writ petition has been filed. It further appears from the records that an affidavit in opposition has been filed by the respondents. In the said affidavit in opposition, it transpires that the amount of rupees 13,27,714 was not taken into consideration on the ground that the petitioner failed to submit any proof that the said payment was invariably relatable to the pending litigation. Taking into account the above, this court, taking into account the above, and also the challans being a part of the affidavit in reply filed by the petitioner on 27 January 2023. This court directs the principal commissioner of GST,
Central GST.
Central GST, to examine as to whether the challans enclosed therewith as Annexure A are in respect to the pending litigations, the reference of which was made in the form number SVLDRS1. And file an affidavit in that regard. List the matter again when? Why? What is there? This small matter out there.
Oh, that is there. Lordship.
I have, in fact, with the first person I have already written. The last portion is only the conclusion.
Lordship, what happened? The principal commissioner is promoted, Lordship.
Okay, get the another fellow, the joint commissioner.
Lordship, I'll
Direct the joint commissioner. We'll ask because he is also one of the parties to the year.
Lordship.
Let the joint commissioner do it. The joint commissioner CGST. Let the matter be again listed on 24th of August or 31st of August. 31st. Yeah. The affidavit be filed by 30th of August. Because if it is not there, has no relation with this thing, then obviously this will hold.
Lordship.
Because the challans are already there
Yes, it is there. Lordship.
in the affidavit. So have a look out there.
Lordship. Will do.
We filed an additional affidavit also with the challans.
Hmm?
We have filed an additional affidavit also with a copy of the challans.
That is the affidavit I am replying to, where in that you have enclosed as Annexure A. Yes, madam. You are waiting on the morning. What matter is there?
Number 9.
Oh, that's it. Anybody else? Any other matters?
Item 8 is there, Lordship.
It is what?
Lordship, 8 to what happened, the petitioner filed an application seeking 100% exemption.
Oh.
They preferred appeal. That appeal is decided in favor of the SEC. In the meantime, that BVF judgment come. So there will be BVF judgment, Lordship.
Oh,
That Supreme Court has, they're claiming on the basis of writ appeal passed, on the basis of the writ appeal decided by this one court. against that we preferred SLP. That was decided in favor of the department. Lordship. Now they are entitled to benefit under notification 2008, whereby the 100% was reduced to 58% or some other percent. That is the case.
You are there?
Yes.
Yes, what is the matter?
For 8.
Sarda plywood. Yes, it's a 2015 matter.
Yes, sir.
What are you asking for?
The part relief I have got from Sestat, my lord.
You have got from?
Sestat, Central Excise Appellate.
Then why are you out here
And the subsequent.
setting aside and quashing the impugned notification dated 20/2018 and Iman? And a reader should not be issued directing upon the respondent to grant 100% so and so, as per so and so. Now what remains after the VVF
No,
judgment?
nothing remains. On
Then-
that line,
VVF judgment,
my lord,
nothing remains.
there were two issues. But whether I'll get the benefit of a new unit or not, my lord. My lord, the Central
That
Excise.
is not your prayer here.
No, no, my lord, just coming.
I'm not on that, but here you are challenging those two notifications which have been upheld by the Supreme Court. And what remains? You're not asking for anything, or you some exemption or some you are entitled to or not. That is not a part of your case. You said that I am entitled to as per these, and as such,
My lord,
on the ground of promissory estoppel, this is done, isn't it?
Yes, sir.
Nothing remains in view of that. Give me that. VVF,
2020.
hey, continue.
2020, 20 SCC page 57.
One less burden to Mr. Kyle. Yes.
but in fact, this percentage based refund also I was not getting because the matter was pending before Sestat. They have gone into appeal, my lord, there was no stay order. It was pending from 2012. Now it has been decided recently.
Should I say that you are not pressing in view of this judgment? I think
Why
better off. Because if I say that I dismiss it in view of this judgment, any benefit which you have otherwise got may
No,
affect.
I have not got one. That is the whole,
But that is not the issue here.
but because I have made a pleading to the effect.
No pleading business. Here you are asking that 20% of these two should not be, and why you should not be given 100%.
Yes.
Then where is your any other prayer?
No other prayer. Because my prayer main was pending before Sestat. Now it's been decided. Had it gone against me, my lord, in fact, I was not entitled to make this prayer.
So that is why I am saying, as you have got some benefit from Sekya,
Hmm.
should I dismiss this petition, or you say that not press in view of the judgment of this? That is why I am saying
Second option is better for me, my lord.
not press.
Yes.
In view of the, because then it may not affect the others.
Only.
This
only-
law will prevail for you only, that's all.
Yes.
And where there has been nothing said as regards your eligibility.
Yes, sir.
I think that is a better option,
Better option.
and keeping it open.
Only one thing, my lord. Can it be indicated, my lord, because I have got the relief in Sestat because I have pointed it out. I have
Yes.
filed the my lord. I have given a copy to your lordship, my lord.
Where?
It is annexed in the,
No, it's not been annexed.
no, it is there on the file note. On the top of the file note, it is there.
Oh, this one.
Yes, sir.
Why these matters are not then disposed of? Simple matters then.
No, recently this judgment has come.
So what? This was given out here.
Same court.
So I will say that you are not pressing in view of this judgment. However, the not pressing shall not affect
Yes, sir.
the outcome of what, shall not affect the decision in this judgment.
Or rather, my lord, in view of both these judgments, I am not pressing this relief. Because that relief has been given to me by the.
The learned counsel petitioner, Mr. R. Dubey, submits that in view of the judgment of the Supreme Court in the case of Union of India and another versus MSBVF Limited and another, reported in 2028 2020 SCC 57, as well as the order dated 15/6/2023 passed in excise appeal number 670 of 2012, passed by the Custom, Excise and Service Tax Appellate Tribunal, Kolkata, Eastern Zonal Branch, Kolkata. The petitioner is not pressing the instant writ petition. Taking into account the above, the instant petition stands closed.
On the basis that he is also bound by that judgment.
Why should you say anything, Mahoday? That is why I say that I close on the, you are withdrawing on basis and this, and the withdrawal shall not affect the outcome of this. That would have been better, but you want this.
Let's see, my presence may be recorded. My presence may be recorded.
No, you give your presence. I don't record anybody's name now, unless he says something. This you put it. We'll put on the name. This happens like put number 1.
Nine.
Your lordship. The case is relating to my lord. Release of subsidy, my lord, but the unit is a my lord. Pharmaceuticals unit, my lord. I have prepared a salient points, my lord, for your lordship convenience. Your lordship, your trial. It can be. It can be.
Yes. So your case is for the Central Capital Investment Subsidy.
Yes, my lord. I was processed. It was,
They have rejected. Why?
my lord, the pollution control board certificate came later on, that's why. There's my lord, one for consent to establish was on time, although I have applied, but consent to my lord, what is called, my operate.
Show me
As it
the subsidy scheme. What does it require?
Annexure one, my lord, annexure one. At page 21. Notification. Then
Where is it mentioned that you have to have a pollution certificate? Each year will set up a state level committee in an industrial
Interesting,
unit
that is
set
not
up
there.
and without the assistance of financial and social consideration. In any.
it is a second unit, my first unit.
No, where is it required that you require a pollution certificate? As per the,
State government policy,
Huh?
state government policy, not in the central government policy.
where is it state government policy?
State government policy, my lord. It is in the, my lord. 2008 policy,
Huh?
that is my lord.
Who is the name for us? Government.
Pollution control board.
Huh?
Kalita who is
Industry
appearing on the screen.
Pollution control board has no business out there.
Lordship, in fact, Mr. A. Kolita need to
Kolita.
address this issue because
Where
I
is he?
put a need to.
Lordship, he is in lakhs, lordship in court 2.
What?
In court 2.
Let us see whether he's in legs in court number 2. Live streaming court.
We are only on. motor
Policy,
vehicle.
my lord, at
We need to.
page 101. I've given.
Have
you
they
my
filed the
lordship.
affidavit?
Yes, my lord.
What is their stand?
Then,
No,
my lord,
because you see, your entitlement to the capital investment scheme is on the basis of a policy decision.
policy.
And there is a scheme.
Central policy, my lord.
Central
Yes.
policy and the central scheme.
Scheme
The
has
state,
were about, my lord, that regarding pollution control. It is the state matter, my lord. The state policy also, my lord, speak about pollution control board certificate.
where?
That is, my lord, I have annexed at page 101, my lord. Government of Assam, industrial policy of Assam. 201.
101.
Yes, ma'am.
I don't have a 101 page. I think 101. Yes, government of policy.
Then, my lord, if your lordship see the 103, page 3, it comes at serial number 27. List of industry under orange category.
10 years.
Then pharmaceutical formulation.
The industrial policy has been given the list of, are you saying about this for page 14, 102?
Yes, ma'am.
The industrial policy in clause 3, 4, 5 and 6 have given list of various industrial categories as non-polluting industry, green, orange and red. It has been resolved that all these industries categorized in non-polluting industry and green, the prospective investor need not have to go through the arduous process of obtaining consent or NOC from Twelve. The green and non-polluting industries can straightaway set up and buy software. Of the demand will be granted a simplified consent. You are what is your business?
Pharmaceutical industry making ointment, tablets, etc. Pharmaceutical.
Tablets. So you come under orange.
Orange. And my lord, the first unit in the ground floor, they are already having the certificate.
No, is it anywhere mentioned
Yes, my lord.
where list out here? What are the automobile, cashew, wood,
27.
floor, food additive, tablet is where? Medicine,
In the beginning, it's
manufacturing of demand, manufacturing soap, non-alcoholic
Capsules.
beverages, organic pesticides, petroleum, pharmacy. You are come under 27,
Yes, ma'am.
pharmaceutical formulations.
Yes.
Who is respond number 5? Assistant Director of Cottage Industries. What business does he have? Consent to
Respondent
certificate to
mentioned,
the initially on
District
so and so up
Industrial
to Iman and later on issued another one on 20. The minutes of the meeting are self-declared in Iman. The detail to the petitioner was on the present that the petitioner obtained the consent and so and so respectively after the expiry of the notice so and Let us see this industrial policy of
Yes.
2017, 2007,
Yes, my lord. Page 21.
page.
21.
Okay. This is the industrial policy. No, this is the capital investment. Where is the industrial policy?
This is the policy, my lord.
No, madam, this
District
is not the
Commercial.
industrial policy. Where is the industrial policy?
Department of Industrial Policy and Promotion.
We are not taken private. This is for, you have expanded.
Expansion unit. For the subsidy is, my lord, applied for expansion unit.
No, no, madam, you have to bring in the industrial policy of 2007. Where is it? It has come into effect from so and so and remain in force up to a month. Now, you see,
That is there,
new
madam.
industry,
It is-
no, industrial unit means an industrial undertaking subsidiary so and so. New industrial unit means an industrial unit for setting up of which effective steps were not prior to so and so. Existing unit means an industrial unit for setting up of which effective steps were prior to so and so. No, to get the benefit under the industrial policy,
Yes, madam.
one needs to do what?
First, my lord, they have to set up the industry by taking loan or whatever.
No, they have to go for commercial production.
That is when after setting up of the industry, my lord, commercial production. Before that, my lord, inspection is takes place. ma'am. The industry, my lord, general manager in the district, my lord, he and the functional manager, they.
Now tell me whether
all the
you,
papers,
no,
they
wait,
tell-
whether the new diversified unit
Yes,
have gone for commercial production
yes,
during the period of the industrial policy of 2007.
during the policy, yes.
From
During
2000, the period of the industrial policy was from 2007
the-
to 2017. Within this period,
Yes,
whether the diversified unit
Yes, ma'am.
of yours have gone into commercial production.
Yes, ma'am. I'm telling the date number. Date of commercial production, my lord.
Because that would be given as per the central excise authorities also. You must be getting the central excise benefits.
Exercise certificate also, dear my lord.
Yes, where is it?
It is my lord, page 27, 28th of March, 2017, commercial production.
27, common. This is an application for the 27, 28 is what? Power is 19.
Column A, my lord,
A.
3A, whether new
Application
unit is.
for consent. Inquiry to consent with. No, madam, I think you, what you need to do.
In so many cases, I have this notification, I have enclosed, my lord. Yeah,
No,
last year
you,
we
madam,
get
let me
yes.
tell you. Listen,
Otherwise,
it is not an old case.
Booklet
No,
is
madam,
free
listen. You file an affidavit, additional affidavit,
regarding-
bringing on record 2-3 things. First, the industrial policy of 2007.
That is, my lord, is a big booklet.
No, only for that. The first,
Booklet
it
I put
is only 7-8 pages, not much more than. You are not required to enclose the other portions. Does the NEEIP
Yes.
enclose
I have got
that?
the booklet, my lord. Yes.
No, you don't
Color
require,
booklet.
only the policy, only the industrial policy, the remaining are not the policy, these are notifications. We are not concerned. Second,
Yes, ma'am.
you have taken central excise exemption,
Or not.
100%.
Okay.
You are not, nobody sets up an industrial policy for the 30% of capital subsidy, no. The basic reason why everybody does is for the central excise exemption. So when the central excise exemptions are granted, prior to that, to give the benefit, the Assistant Commission of Central Excise has to give a order saying that they have gone onto commercial production on such and such date. That order you enclose. After enclosing that, this will show that you have gone into commercial production, and as per the particular industrial policy, you have to go for commercial production in respect to the diversified units within that period. And if you are bringing them, then the industry department has no business there. You file an additional affidavit bringing those. Because throughout my practice, I have done these type of matters.
Yes, my lord.
So that is what I am telling you.
I know, my lord.
That is why you need to bring
Regarding
these two.
Central
Once you
Excise-
bring in these two, because there is already a decision by an authority saying that you have gone into commercial production and you have been given the central excise. Now, once you are getting the central excise, these people have no business out there to say that, no, I am not going to give it.
I've seen in the file, my lord, regarding central excess certificate.
Understood? Where is it? It is not here.
It's not there. I
Yeah.
have to file it.
So you bring these two aspects. Okay.
Lordship, there might be an affidavit from Pollution Control Board, Lordship, I'm not sure. I think
It is there,
they
it
might
is
have
there.
taken the plea that since they cannot start commercial production prior to, obtaining this consent to operate. That might be the means.
That is the
basic
main
issue
reason
in
of
this case,
rejection.
Anyhow, because we are not the legend, I'm not crossing my limit.
No,
Lordship.
no, understood. You may say that, yes, they have not, but I am asking you, this is a diversified unit. This is not a new unit.
Expansion unit is.
It's a diversified unit. Being a diversified unit, they must be having, they have been all along having a consent. So the consent, because what they have done, they have only extended the capacity by more than 25%. It's not a new unit. So prior to that also, there is already, they are operating and you must be having, must have given a consent. You see, you can't have the same, and I've understood it's a new unit. If it is a new unit, a commercial product, that consent is required. But if it is a diversified unit by which they already have a consent, but what they have done is they have only, there were certain machineries or certain diversifications being brought in by which they have made or improved the production and spent or incurred expenses more than 25%. That is what it is. That is why I've asked her to bring on record the thing. That is the reason why. Because this, otherwise, this capital investment subsidy does not show so. So if that be there, then obviously they have. And then the question of the consent or no consent, because otherwise they are operating. How are they operating? You see, it is the same
They have
industry.
issued both the certificate, but later on.
No, maybe, but it is the same industry.
Earlier, the same industry, my lord. As earlier it was in ground floor and now, my lord. they have
Because
set-
otherwise, because another in spec out here,
The salt that may kindly be fixed. On 8th of March. Page 39, my lord. To the superintendent of central excise, 777. Page 39. Estimation performance of product.
you see, here they say the date of commercial production was 28th of March 2017, very much after the date of application and inspection, when we have already been complying with the norms. So they say that the commercial production happened prior to the, which is the requirement as per the industrial policy. And where do you bring in the consent? Yes, there might be some violation being committed by the without the consent they have operated. But are you going to say that the consent without being operated would disentitle them, or there has been no commercial production? Because the industrial policy only says about commercial production, nothing else. Madam, you file it.
Page 39, your lordship, may kindly see my lord.
It's
Letter
page
to the-
39.
39. It is intimated to the panel of central excise.
No, this is your letter. That is what I'm saying now. On 28/3/2017, you have stated, no, there will be an order passed by this assistant commissioner.
Yes.
Bring it on record, because then it will show that you have gone for commercial production.
Yes.
Ms. Ensoike, the learned counsel appearing on behalf of the petitioner, seeks for an accommodation for filing an additional affidavit to bring on record the industrial policy of the year 2007, as well as also orders passed by the Central Excise Authorities, whereby the commercial production, the date of commercial production has been duly accepted by the state authorities. List again, well,
17, my- 17 about.
17 is too early. Don't you think
The
so?
next day, is better.
On 24th, 24th,
Yes, sir.
on 24th of August 2023.
We have some matters, Lordship, on 24th.
Who?
So Lordship, on 24, we have some matters.
Who are you? Who are you?
Sir, on behalf of A. Kalita and
Where is your Kalita? Now I am saying, wait. This court further expresses displeasure in view of the fact that the Industries Department of the Government of Assam is not represented.
No, like,
Sorry, Lordship,
You are appearing?
on behalf of A. Kalita.
No. Are you appearing for Industries Department or not?
Lordship, yes, sir.
You are?
On behalf of A. Kalita.
No. Are you
Yes,
appearing
yes.
for Industries Department?
Yes, sir.
Okay, now come here. Tell me. On what basis have you said that the pollution certificate is required?
No, I didn't say anything.
No, that is your order. You have rejected her because of that. Why have you said that? Why have you rejected on the ground of pollution control, pollution certificate?
Lordship, regarding this matter, Lordship, I am not aware, Lordship.
So none appears. This court expresses great displeasure at the Industries Department of the Government of Assam, which is the main party, is not represented by anyone. Okay. Yes, anybody is waiting for what? No other matters? Well, I don't rise so early.
Yes.
Madam, only one thing. You remember that judgment I delivered for the purpose of
LPG distributor,
that
my lord.
residence?
LPG distributor, yes.
Yes,
I have given him the number today.
you have given, na? So that day, yesterday, I got some other matter, so I didn't know about it. Yes. What has happened? Any appeal file?
Both the parties has filed appeal because your lordship has not given me. So my appeal, I also filed that next week, both the appeals are fixed.
Okay. So therefore, I will, because there's some other matter where I forgot that citation which I've taken out from the
Citation
Supreme
is
Court.